Good afternoon, everyone. Can everybody take a seat, please? So, it's a pleasure to welcome you to the panel on advocacy towards universal ratification, successful strategies. This panel is sponsored by ACAED France and the World Organization Against Torture. My name is Carin Benninger and I'm the Deputy Secretary General at the World Organization Against Torture, and I'm based here in Geneva. And I will be the moderator of this panel. The Convention for the Protection of All Persons from Enforced Disappearances has been ratified by 77 states. I don't know, I hear myself speaking. Is there, I don't know who has it open. Do you have it open? No? Okay. There is an echo. Do you hear an echo as well? Yeah.
Speaker is good. I don't know how to stop this.
Hello? Yeah.
This one.
Yeah.
It echoes.
Yeah. Nordine, there is an echo. We have a technical issue here. Yeah. I'm really sorry. I will continue for the time being. So the convention, the CED convention, has been ratified by 77 states, with Poland the last the last ratification on 30 December last year. So compared to other international human rights treaties, the number of ratifications is notably low. So over the next 2 hours, our panelists will share their experiences with promoting the ratification of the CED Convention, as well as other treaties, like the Convention Against Torture and the second optional protocol to the Covenant on Civil and Political Rights on abolishing the death penalty. They will discuss effective strategies that have worked and explore how these approaches can be adapted to different contexts to support the goal of universal ratification of the CED Convention. So before we begin, let me outline the format of this afternoon session. So we had actually planned to have a 2-hour panel, but since we have a delay, as you may know, we will reduce this panel will be shortened to 1.5 hours. So this session will feature 3 panels, each consisting of 2 to 3 panelists. Panelists will respond to 3 specific questions, which each have given a time limit of 3 minutes to formulate their answers. Adhering to this time limit is crucial to ensure equal speaking time for all panelists to avoid rushing through the last panel, and as you know, we have a delay already. So after the 3rd panel, there will be a Q&A with the audience, during which we will take some questions. And at the end of the session, Solange Momé-Etienne, the Director of Programs of ACAED France, will provide an overview with the key recommendations that have been shared by the panelists towards the universal ratification. So, but finally, before introducing the first panel to you, I would like to remind everyone of the session's code of conduct. To ensure a respectful and constructive dialogue and discussion, we ask all speakers to adhere to the following guidelines. We agree to disagree, no inflammatory language, 1 intervention at a time, no interruptions, stay on topic. Panels are not meant as a platform to deliver political statements. Adhere to time limits, and if you are asked to conclude, please respect this for the reasons mentioned earlier. So we will now start with the first panel of this session, reflecting on the current trends in different countries and continents regarding the ratification of the CED Convention and the road ahead. Is it you?
I don't know why.
It's your phone.
How we got connected?
I don't know.
I have no idea.
Is it okay? Yeah, you have to turn off your phone. Sorry about this. So it was actually the phone of one of the panelists that we produced on my speech. So good. Thank you so much, Saman. So I have the pleasure of introducing first Aileen BACALSO. She is the Executive Director of the Asian Forum for Human Rights and Development, Forum Asia, a network of 87 member organizations across Asia. She is also the Honorary President of the International Coalition Against Enforced Disappearances, which is mandated to campaign for the universal ratification and implementation of the International Convention for the Protection of All Persons from Enforced Disappearances. She has worked on the theme of enforced disappearances for more than 3 decades. Our second panelist is Mohammad ASHRAFUZZAMAN. He is a human rights defender of Bangladeshi origin, working on civil and political rights for nearly 3 decades. He has documented cases of torture and arbitrary deprivation of life, including enforced disappearances in his native country and other Asian countries. Currently exiled in the United States, he globally advocates for accountability of perpetrators and reparation for victims. We have actually a third panelist who has not yet arrived. I will introduce the third panelist upon his arrival. And we just continue with the first panel, just with the two panelists right now. Yeah? Yeah. So, Mrs. BACALSO, let me start with you. So, victims of enforced disappearances are the raison d'etre of the Convention for the Protection of All Persons from Enforced Disappearances. So, can you tell me what has been the role of victims and their organizations, including the International Coalition Against Enforced Disappearances, in advocating for the ratification of the Convention of Enforced Disappearances? Please, you have the floor.
Thank you very much, Carin. Thank you also for the kind introduction. So victims of enforced disappearances are in the best position to tell their stories. As we heard this morning during the plenary, we have heard a number of families of the victims or victims themselves. So their stories are the most powerful basis for campaigning for the ratification of the convention. And this was proven during the 3-year drafting and negotiation process of the convention in Geneva from 2002 to 2005. The substance of the convention, the International Convention for the Protection of All Persons from Enforced Disappearance, stems from the true-to-life experience of the disappeared and their families and relatives. So from our experience in the different countries of Asia, in other regions of the world, some of the most important roles victims play include, first, in terms of the search for truth, documentation of cases, which concretely states the context of enforced disappearances in the respective countries and the specific circumstances of the cases of enforced disappearance. Then second is the conduct of various forms of campaigning and lobbying. For example, the popularization of the convention, because in many different countries, not many people know what is enforced disappearance, and much less the Convention Against Enforced Disappearances, even in universities. Fora and public events to popularize the convention, alternative reports to the UN during the Universal Periodic Review and concrete lobbying for recommendations by states party to the convention for them to be able to recommend to particular states under review to sign and ratify the Convention Against Disappearances, coupled with activities at the national level. So when we did lobbying at the international level, our colleagues at the national level were also conducting simultaneous activities at the national level and cooperation with national human rights institutions and the use of the media, which is very important. Then we also lobby for sponsors for drafting of domestic laws against enforced disappearances, especially those sponsors from the parliament who have themselves their own personal experience of enforced disappearance, if any. Then lobbying and campaigning for full implementation of the convention once adopted and implemented. It should be important to have these laws implemented because any law is only as good as its implementation. Thank you.
Thank you very much. And turning to Mr. ASHRAFUZZAMAN. How was that in Bangladesh? Could you tell me what the role was of victims of enforced disappearances in the sudden accession of Bangladesh to the CED Convention? And could you name maybe some other triggers? You have the floor and you have 3 minutes to answer.
Thank you very much. I'm very much privileged to be here with all of you, the inspiring victims and the human rights defenders, colleagues from different parts of the world. The case of Bangladesh, the background is there was a one-party rule for 16 years, and that turned to be one individual's rule. So in that system, the political position was institutionalizing the arbitrary deprivation of life. And in that context, the people had to work, the victims and the human rights defenders who existed inside the country, and some of us who had to choose to live in exile for more than a decade. So we worked. So we had to take multidimensional approach in a way engaging. It began with authentic documentation, of course, and without that we could not move on. Then supporting the families of the victims so that they remain, always active and speak out about what they have been facing and the situation and the demand for justice for their loved ones. Supporting the one of the things that we did, as Aileen mentioned, that consistent cooperation with the UN Special Procedure Mechanism and the OACHR, and they also cooperated with us with regular interventions throughout this 16 years of time when Bangladesh experienced hundreds of enforced disappearances. My colleague sitting here, who is part of the Inquiry Commission of the Enforced Disappearances, they have learned that over 1,700 enforced disappearances took place in the country during January 2009 to August 2024. So, and then we also made a lot of other interventions, written statements, oral intervention in the UN Human Rights Council. Personally, I did that, and the periodic report, the alternative reports, the UPR report engagement, all of those things. And we also engaged the victims. We did like WGID, the Working Group on Enforced or Involuntary Disappearances. So there are a lot of other things that we did. We tried to engage with other bodies, for example, where accountability could be, implemented or useful. For example, the Magnitsky Human Rights Act of the United States, that we tried to explore and work on that, and it successfully worked against 7 perpetrators. So I'll come back later, having more time for the participants to ask questions. I'll stop now here, and thank you very much.
Thank you very much. And I'm very glad that Mr. Idrissa has arrived, our third panelist. He is commissioner at the African Commission on Human and People's Rights, chair of the working group on the death penalty, extrajudicial summary and arbitrary killings and enforced disappearances in Africa, and judge at the Supreme Court of Senegal. Mr. Sow holds a doctorate in public law and is lecturer at the Institute of Legal Professions at Sheikh Anta Diop University in Dakar. Welcome.
Thank you.
And I have also the first question to you, and you have 3 minutes to answer. So how is that in Africa? We were speaking about the role of victims and human rights defenders that have played an important role in the ratifications. So what role do human rights defenders and victims play in the ratifications in Africa? And what are other trends that you have observed? Mr. Sow will respond in French.
Thank you very much, Madam the chairwoman of the session. I'm going to start by introducing me because I was not here at the beginning of the session. So I'm going to start by expressing my pleasure to come here to exchange my opinion with all of you about this issue. On behalf of the African Commission on Human and People's Rights, ACHPR, this is a reality. Forced disappearances are a reality, a diffused reality in Africa. And I say it's a diffused reality, but today we do not have any statistical figures that allow us to give you an idea about the depth of this problem. And we actually defend human rights protection, and we believe, well, we take forced disappearances as a serious crime, even though the African Charter on Human Rights, which is our instrument, our reference instrument, does not talk about forced disappearances. For a long time, these issues have been dealt with through other violations. Other violations that violate the law and that have an arbitrary the arbitrary killings. And in this context, forced disappearances have been treated. What's most important is that nowadays we consider this as a very serious crime. And our approach nowadays is not to go towards the setup of a specific legal instrument for Africa. There is no public interest nowadays to have yet another convention. That's why we took assume for the African Committee on Human Rights to adhere to the Universal Convention, the International Convention for the Protection of All People Against Forced Disappearances. But we have not stopped here. Since 2022, we have what we call the Directive for the Protection of All People, including forced disappearances, which has as a main goal to help states to actually adhere adequately to the obligations of the International Convention. How do we do it, Madam the President, to respond exactly to your question? What is the current trend in terms of the ratification of the Convention? Well, I can tell you that currently we have a positive trend in Africa, given that nowadays we have 20 member states that have ratified the International CEDI Convention. We're still far from our goal because our goal is to have a full-fledged and universal ratification. But from my point of view, it is a start that is quite encouraging. So clearly nowadays, we actually encourage member states to ratify the convention, and we do it in different manners. First, in the framework of the public sessions lawyers have every year, a year, and here we discuss issues concerning forced disappearances. And normally, this is exchanged with the state with regards to the problem of false disappearances, and we invite them to ratify the convention. And we also use other tools and other opportunities. For example, the promotions that we carry out in the different states. And because let's not forget that as an African institution, we have the mandate to protect, but also a mandate to promote. And under the headline of this promotion mandate, we promote in amongst different states to encourage them to any cases related to false disappearances. And that also helps us for them to ratify the International Convention for the Protection of People Against False Disappearances. So this is what I can tell you, Madam the President, what I wanted to say about current trends in terms of the ratification of this convention. Thank you.
Thank you, Mr. So, and I will stay with you. So regarding the guidelines for the protection of all people against enforced disappearances in Africa that was adopted by the African Commission on Human and People's Rights in the spring of 2022. Could you elaborate on these guidelines and how they could be best used to foster avenues for more ratifications of the convention in Africa?
Yes, indeed, these directives are used as a tool for specific states to help them to commit themselves and align their internal legislation with regards to what is demanded by the International Convention. That's the first point. The second point is that in that document, the Commission has disciplined its doctrine with regards to prevention and the protection of all people against false disappearances. And if we read the preamble of this directive, these directing lines, they ask states to ratify the convention. So to respond to your question, Madam the President, we use this directive, this directing line to encourage and promote the ratification of the convention among states. And to us, it is the reference legal instrument in terms of the struggle and the prevention against false disappearances. In general, we carry out promotion strategies and campaigns, and through these, we always have a basis that allows us to promote the international legal document, which is the International Convention for the Protection of All People Against False Disappearances. So one goes in hand with the other. The directing lines that we adopted in 2022 are a complement to the International Convention. And every time we promote these directing lines, we take advantage of the opportunity to also promote the universal ratification of this International Convention for the Protection of People Against False Disappearances.
Thank you, Mr. So, for this valuable insights. Turning back to you, Mr. ASHRAFUZZAMAN. In Bangladesh, so what lessons could be learned from your experience in terms of ratification strategies?
In Bangladesh, what from our perspective was important, the contextual knowledge and the cautiousness in terms of the protection of human rights defenders who were based in inside the country, and the victims, particularly in the given political situation. Then we always try to ensure that the authenticity of information and the prompt utilization of that in documentation and engagement with the appropriate professionals from the UN to various multinational bodies and entities, that has been properly utilized for the objective of getting redress of triggering accountability on the issue of enforced disappearances, having the knowledge that and the experience as well, that the domestic judiciary has never, as of today, addressed any single case giving any assertive remedy to the victims of the enforced disappearances, and particularly during the deposed government. And that was, we also had the needed the compassion to the victims. One of the lessons that there is struggle, particularly the women, children, they are helpless, they are moneyless, they are assetless. There is a very complex situation for all of the victims, and that needed our active attention on a daily basis to many of their support for schooling of the kids and festival time of support. So our colleagues, our friends who are based in the country, we tried our best to channel the resources, although doors were closed by the government. Then at the same time, we needed a sustained ability of the human rights defenders in the country that to manage the trauma, because dealing with the enforced disappearances cases is it's a highly traumatizing for everybody else who are involved in the with the work as a whole. And the frustration of the justice system is part of that. So I mean, and keep moving with the demand, and also keep working on the issue, taking up innovative approaches, as I previously briefly mentioned, with the international other accountability mechanisms. And one of the things is that making a space for the people so that they get more opportunities to enjoy or widen the scope of freedom of assembly, association, and expression, and particularly media. We had a lot of engagement with the international media that because local media has a serious censorship issue. So we had to, I mean, keep the international media engaged so that they could focus consistently on that. And we tried to speak up regarding the issue, analyzing the condition. So, and of course, it was not one person's job, as we all understand. A lot of international human rights organizations, the colleagues who are sitting in this room, they all contributed through continuous documentation, special reports on the situation of Bangladesh. I just used some of these in the, you see the highlights of the photos. So this collectively work, and that is the lesson that we have learned, that a multidimensional approach required to address enforced disappearance in a very highly challenging political atmosphere of the country. I thank you.
Thank you so much. Turning to Mrs. Bacalso, listening to the former speaker who pointed out that the journey of ratification is not an easy stroll, but it's long and can be difficult, and one that needs endurance, partnership, resources, specific competences. So what are, according to you, the challenges ahead to take into consideration for more ratification of the convention?
Thank you very much for the question. It's true that there's a lot of challenges, and as a matter of fact, we have only 77 states party to the convention, taking into consideration that enforced disappearances are happening in many, many countries of the world. And it was mentioned earlier during the plenary that the Convention Against Torture has garnered universal ratification, 170 plus states party, but we only have 77 states party to the convention, considering also that this convention was adopted by the UN General Assembly almost 20 years ago. So it is the treaty compared with the other core international human rights treaties. It's the treaty with the least number of ratifications. And based on experience in the drafting and negotiation process of the convention and actual interaction with states post drafting and negotiation, challenges to ratification include issues of sovereignty, because this is being invoked by many states during the drafting of the convention, issues of sovereignty, non-intervention, and self-determination. And even after the drafting and negotiation process, when we lobby at different foreign affairs offices, we always got the same issue that we cannot give up our sovereignty. Then there's also fear of international scrutiny due to past and present unresolved cases of enforced disappearances, and there's a lot of impunity. And in the case of the Philippines, for example, the Philippines said that since it already has a domestic law against enforced disappearances, the convention is there's no need for the convention to be ratified because there's no added value to the convention. And there's also fear of deprivation of support from other states which are against the convention, and internal limitations of civil society organizations, victims' organizations in sustaining the campaign because of constraints in terms of resources, internal divisions between and among civil society organizations, and at the sub-regional level, there's a lack of regional support from existing official sub-regional formations. And in the case of Asia, ASEAN is the sub-region that has the lowest number of ratifications, and the South Asia Regional Cooperation, the SAARC, is not functioning.
Thank you very much, Mrs. Bacalso. I would like to ask the same question to you, Mr. ASHRAFUZZAMAN. So considering your experience in Bangladesh, what recommendations would you like to share here?
The first thing is I would request the world leaders that let's consider the problem of parts of the world in a way that it's one body. So that if my finger has a pain, then my whole body pains. So, and we need to address that. We need to treat that. So the same way, if a problem either in any of the African countries or the Asian countries or wherever, we need to stand by the victims, and also we need to raise our voice and do everything possible so that the enforced disappearance could be stopped and justice could be afforded. So that is, it should be an integral part of our daily life and commitment, from politicians to civil society and everybody else in this world. And the second thing is, enforced disappearance or any form of human rights abuses like arbitrary deprivation of life, it's a political decision at the end of the day. The government of the day in every country, they have a policy of not respecting people's rights. And that's why we face this. So then what we need is the kind of government that has democracy, rule of law, with the commitment of protecting people's rights and cooperating with the international instruments like ICCPR, the convention. So we need to adhere to those principles in a demonstrated way, not like in words or in papers, that in everyday life, our actions can prove that we really have a commitment. The human rights defenders are one of the first people next to the victims who need the support. So whoever has the resources for human rights issues, please make sure that the support goes to those people who are every day suffering or trying to protect or save someone on the ground in different parts of the world. The next thing is the accountability of reprisal against human rights defenders and perpetrating the human rights abuses. That should be everyone's top priority for every government and also everyone who want to see a better world. And a peaceful world. And of course, the other thing that I would say, that we also need the substantive knowledge about the geopolitical, socio-economic, cultural and historical developments of the particular region or particular country that we are. Why I'm saying that, because there are neighboring countries, sometimes the other countries, they use rendition and various kinds of tactics to unleash human rights abuses. In this case, for example, Bangladesh's biggest neighbor that housed many victims of enforced disappearances. Some of them directly told us that they were picked up in the Bangladeshi soil and then they were handed over to the Indian officials. And they stayed months and some of them years. So this, cross-country, collaboration in committing enforced disappearances crime against humanity under Rome Statute, so to say. So we went, and that's why the demonstration is important, that we don't cooperate in committing crime against humanity like enforced disappearance. And the last thing that I would say, that keep up the resilience of affording justice to everybody. I thank you.
Thank you so much. And now the same question for you as well, Mr. So, building on your analysis of the African continent. What kind of recommendations would you like to formulate here from a more global perspective?
Merci, Madame la Présidente.
Thank you, Mrs. Chairman. Just to formulate my thoughts, my recommendations very clearly, I will orchestrate them around three keywords. First one, cooperation. Second, report. And third, collaboration. Firstly, we need to strengthen cooperation at the international level for the organisms who work on the prevention of enforced disappearances. I would like to send you to Article 28 of the Declaration, who engages the committee to collaborate with all authorities for the prevention of enforced disappearances. And we have a similar disposition in our African Charter for Human Rights. So first keyword, cooperation. The second one is something we already have. We just need to strengthen it. Why do I say that it already exists? Because, for instance, with the special process from the US at the level of the African Convention of Human Rights, we have our roadmap, which posits common actions that we need to widen. We need to widen this cooperation to integrate all the organs at the international level to protect and prevent enforced disappearances. The second key element that I would like to point out is the report. Accountability against the states. It's not just about asking states to ratify the convention, but to hold them accountable to all the obligations that come with it. The first obligation that comes to mind is the need today to have specific commission to sanction, to punish enforced disappearances, because that's not the case in all sports. In some states, these are treated as just regular kidnapping or other crimes. So the first obligation is to make enforced disappearances a specific crime. And then when it comes to the expiration date of these crimes, because they should be universal competences, not just at the national level. And we need to address this question of enforced disappearances. The third keyword that I would like to announce is collaboration. We need a collaboration that is intense between the organisms and civil society organization. We have no protection. We cannot act if we don't have information. And for that, all we can do is lean on information that can be brought to us from civil society organization on the one hand, and the ICCPR on the other hand. For instance, concerning torture, we, at the level of the African Convention for Human Rights, we actually have a mechanism that allows us to gather information very quickly. It'd be very interesting that such devices can be implemented when it comes to enforced disappearances. And just to strengthen, Mrs. Chairman, this is my perspective and my recommendations that can be shared with everyone. Thank you.
Thank you very much, Mr. Shaw, for sharing these important recommendations. And as I mentioned before, all the recommendations will be highlighted once more at the end of the session. So we came to the end of the third panel, and the first panel, and I would like to thank you for your insightful presentations, for being concrete and action-oriented. Thank you so much for that, and also for sharing your important work. Thank you so much, and a big applause to you. So I would like to invite the panelists of the second panel to the podium, please. Thank you so much. Hello. I would like to welcome here at the podium Mrs. Gayatri Pillai and Fatima Barkan. So Gayatri Pillai is the head of the Secretariat of the Convention Against Torture Initiative, CTI. She has held this position since November 2021, providing strategic and policy advice to the CTI 6 core states to deliver their vision, aspiring to reduce and prevent the risks of torture and ill treatment through the universal ratification and implementation of the UN Convention Against Torture. Prior to joining CTI, she was chargée d'affaires en pied and head of Seychelles' permanent mission in Geneva. Ms. Pillai has worked in numerous capacities within the government of Seychelles, including as director of the International Law and Human Rights Unit and as the director of Seychelles' National Committee on Trafficking in Persons. Then Ms. Fatima Barkan, welcome, is Secretary General of the Interministerial Delegation for Human Rights, Kingdom of Morocco. A topographic surveyor engineer by training, she held various positions of responsibility, notably within the Directorate of Territorial Planning from 1996 to 2015. Before becoming Director of Women at the Ministry of Solidarity, Social Development, Equality and Family from 2015 to 2022, then advisor to the Minister of Justice, responsible for equality and parity. Specialist in geographic information systems and gender equality, she has led several structuring projects. She contributed to the publications and participated in large-scale work such as advanced regionalization and the revision of the Family Code. Thank you. So the objective of this panel is to draw insight from experiences and strategies focused on achieving the ratification of the Convention Against Torture. Was a little interruption. You can absolutely stay here, Mr. Mazan, no problem. So again, I will ask both of you 3 questions and you will have each 3 minutes for responding to each question. So starting with you, Ms. Pillai. So what are CTI's success stories in the global strategy leading to the ratification of the Convention Against Torture worldwide?
Thank you, Madam Chair. Firstly, thank you very much for the invitation to myself and to CTI to share our experiences this afternoon. For those of you who may not be as familiar, CTI, or the Convention Against Torture Initiative, was established in 2014 with the core goals of achieving universal ratification and improved implementation of the UN Convention Against Torture by the end of 2024. During this initial 10-year period, we were led by a cross-regional group of states, namely Chile, Denmark, Fiji, Ghana, Indonesia, and Morocco. Since CTI's establishment, a key indicator of our progress and our success has been the 21 new states which have newly joined the Convention Against Torture. When we started a decade ago, there were 154 states, and we now only have 20 states left globally yet to ratify the convention. Of the states that have newly joined, it is interesting to note in particular that over 85% of them are small island developing states and or LDCs. During this past decade, CTI has been pleased to have over 170 states participating in at least one of our events, and we have held over 30 national and cross-regional events throughout the world, engaging various audiences and building capacities across the board. Additionally, we now have the support of a group of friends network composed of experts, organizations, and currently 47 states, who work with us on the shared goals and vision of addressing torture and ill-treatment globally. Perhaps one of the clearest indications of our success and the appetite for an initiative such as CTI, who support states on ratifying and implementing the Convention Against Torture, is the fact that our mandate has now been extended for an additional 6 years until the end of 2030, and with the addition of the Bahamas as our 7th leading core state. Our second phase now also involves a greater concentration on supporting states on the implementation of the convention, whilst continuing to support states on ratification. CTI is also broadly a success story for the impact of diplomacy, both at the bilateral and multilateral levels, and to show that change can be effected through these specific modalities of engagement.
Thank you so much, Ms. Pillay, I'm sorry. And thank you for highlighting these significant achievements of CTI and also underscoring its vital role in the ratification strategy. And turning to you, Ms. Barkan, Morocco is one of the core states of the CTI and also of CD, and signed the Convention Against Enforced Disappearances already in 2007 and ratified it in 2013. So could you share with us the reasons behind Morocco's long-standing support for the convention of the CD Convention? Ms. Barkan will answer in French and has a PowerPoint presentation.
Thank you. Thank you, Mrs. Chairman and Mrs. Representative of the CTI. Mrs. Chairman, according to the National Convention of Human Rights in Morocco, and distinguished delegations, ladies and gentlemen, good morning, good day, everyone. It's an honor to be participating with you on this panel, and the fact that Morocco has been a historical partner on this convention comes from its natural engagement with human rights when it comes to the promotion and the protection of human rights, especially the matter of enforced disappearances. It has a will to put its experience at the service of the partner states and the fundamental belief in diplomacy and belief in its partners. And so with its Arabian Muslim Maghreb neighbors to cooperate with Southern Africa. As you know, Morocco was one of the first undersigned in this convention, together with France and Argentina, was adopted by countries who mobilized to ensure that the international community became an functional legal instrument to make sure that such events don't happen again. The ratification of the Kingdom of Morocco of the Convention in May 2013 is a logical continuation of its commitment, written within the Moroccan experience as a leader in transitional justice, accompanied by structural reforms, which accompanied this dynamics characterized by the creation of the instance Equity and Reconciliation in 2004 as an paralegal mechanism to determine the responsibility of the state and its organs, and not just individual responsibility, with its will to reform and reconciliation with fair and equitable rules on the declaration of against human rights committed in the past. We could also quote the process by the representative of victims of human rights violations in this process. Besides, the Moroccan experience for transitional justice has used the dispositions of these conventions when it was only in its infancy, even when its adoption was made by the United States. Notably, the definition, the right to know the fate of the people who have disappeared, and the guarantees of the non-repetition of this human rights violation. We could also quote the significant role of civil society, especially Victims Association, and with a lot of information. The Moroccan experience when it comes to transitional justice, the first of its kind within the region, exists based on a specific philosophy. There's a global approach in the domain of reparation based on financial compensation as well as psychological support, social regularization of and administrative and financial situation. Besides, Morocco is part of the work group on enforced disappearances based in 2009. It hosted one of its sessions in 2016, and it has been working directly with a number of groups. The latest meeting of which happened in 2024. Morocco is also a special reporter. It has a working group on enforced disappearances in 2013, as well as a subcommittee for the prevention of torture and other abuses or inhuman treatment in 2017. Morocco is also a special procedure, especially relative to the creation in September 2011 of the special report on the promotion of truth, justice, reparation. I am proud that my country has made this initiative that will doubtlessly be a auspicious framework for this kind of experience, and it's also a very encouraging fact for the ratification of the convention. Thank you, Mrs. Chairman. I give the floor back to you.
Thank you very much. And Ms. Bakan, in the role of core state to the CTI, what are the specific results that Morocco has achieved in the region?
Thank you again for this question. Continue in English. De prime abord, je tiens à saluer hautement l'implication inconditionnelle du core group de la CTI dans la réalisation de ces objectifs. Comme vous le savez, le Maroc, le Chili, le Danemark, le Ghana, l'Indonésie et les Fidji, en collaboration avec le secrétariat, ont été des acteurs clés de l'initiative de la Convention contre la torture depuis son lancement en 2014. Nous avons travaillé avec détermination pour plaider en faveur de la ratification de cette convention, pour intensifier les efforts afin que ces dispositions et les obligations qui en découlent soient respectées et promues au niveau mondial. Nous sommes très fiers des résultats de cette initiative ambitieuse en rassemblant de nombreux pays et en accumulant une expérience précieuse, tant en termes de nouvelles ratifications que de mise en œuvre depuis le lancement de
for the
cette
ratification
initiative,
that
20 nouveaux pays
since
ont
this
rejoint le groupe des
initiative
pays ayant ratifié
started,
cette convention,
a
dont
growing
10
number of
dans la
countries have
région
ratified the
africaine et du
convention,
Moyen-Orient,
among which
portant le nombre total à
the African region
175 pays
and the Middle
maintenant.
Eastern region.
Tant
So
que certains ne l'ont pas encore signé, nous sommes
certainly
appelés
some people
à
still
redoubler
haven't,
nos efforts
some countries still
respectifs.
haven't signed it, so
Dans
we
une
are doubling
région
our efforts
diversifiée, en structures juridiques, institutionnelles, historiques et
within a
politiques variées,
diversified
le
region on
CTI a
all
travaillé en
accounts.
étroite
The
collaboration
CTI
avec
has
les
been
pays du
working
Moyen-Orient
closely
et de
with
l'Afrique du
countries
Nord,
in the
la
Middle
région
Eastern
MENA,
and Northern
pour
Africa
renforcer les institutions,
to
les lois et les
strengthen
mécanismes nationaux
institutions,
afin
laws, and
d'améliorer
national
l'administration de la
mechanisms
justice,
to
les
improve the
pratiques
administration
policières
of
et
justice
l'application de la loi et les systèmes globaux de gouvernance. Bénéficiant d'une ratification régionale quasi complète de la
benefiting the
Convention,
regional
le
of the
CTI
convention.
s'efforce d'aider les
The
États du MENA à
CTI
mettre
is forced
pleinement en
to
œuvre la
help the states in
Convention en
MENAP
s'attaquant à des domaines
to
très
ratify
spécifiques.
the
Il est
convention
important
on
de
very
savoir
specific
qu'un nombre
domain. It's
croissant d'États
important
de
to
la région
know
MENA ont ratifié
that
le
a growing amount
protocole
of
facultatif
countries
à la Convention des
in
Nations Unies contre
the
la
region
torture
have
en ouvrant la
ratified
voie à
the
l'institution
convention, as well as the Convention Against Torture from
l'institutionnalisation
the
et
United
à la mise en
Nations, and thus
pratique
we
de
are
leurs
institutionalism
mécanismes
and
nationaux
putting in
de
practice
prévention
at the level
pour aider à
of
prévenir
national
la
systems of
torture
prevention
et aussi en
to
visitant
prevent
les
torture,
lieux où
but
les personnes
also
sont privées de
visiting
liberté
places
et
where
en
people
faisant des
are deprived
recommandations
of their freedom
d'amélioration.
and doing
Le Royaume du
recommendations and
Maroc
giving recommendations for
étant
improvement.
fondateur
The
de la
Kingdom of
CTI,
Morocco is a
situé en Afrique du Nord,
founding
il
member
joue
of
un rôle
CTI
central dans l'organisation des dialogues
and
régionaux sur
thus
des thèmes
plays a
d'intérêt
central role
mutuel
in the
pour les
generation
pays de la
of
région. Pour
dialogue
discuter
and
des faits
mutual
communs
aid,
et des voies à suivre, ainsi que pour partager ses propres
and
expériences en
to
mise en œuvre de la Convention et du
share its own
protocole facultatif.
experiences
À
when it
titre
comes
illustratif,
to rules
seulement
and
le Maroc a
regulations
eu
and
l'honneur et le
protocols.
privilège
Just to give an
d'accueillir deux
example,
symposiums
Morocco has
internationaux
had
en
the honor and
2015
the
et en
privilege to
2017
welcome
qui ont
two
offert des
international
opportunités d'échanger les meilleures pratiques en matière
conventions
de
in
prévention de la
2015 and
torture dans la
2017
région du
to
Moyen-Orient et
discuss methods
d'Afrique
to
du Nord
prevent
et de
torture in
discuter
the
les
regions of the
fondements
Middle
de
East and Northern
l'administration de la
Africa
justice et de l'application de la loi.
in
Dans
terms
le
of
cadre de cette
administration of justice
dynamique
and
de sa
law.
propre initiative, le
In
Maroc
this
a organisé
dynamics,
en
out of its own
décembre
volition,
2023 un colloque
Morocco
régional sur le
organized in
rôle des
2013
institutions
a
sécuritaires dans la
regional
prévention de la
colloquium
torture.
on national
Placé sous
security
le
and
signe
torture prevention.
expériences et défis dans la région MENA. Et ce colloque, il a été l'occasion de partager des
Regarding
expériences et
to
des
the MENAP
expertises en
region,
matière de
where
prévention
a lot of
contre la
experiences
torture
were
et
shared
l'examen des moyens
against
à
torture
même de développer les pratiques dans le domaine de la
in
prévention
order
contre ces
to
fléaux.
develop torture
Le CTI il a été très
strategies
utile
against
sur de
torture.
nombreux aspects.
It was
À cette
very
occasion, je
successful
tiens
in
à
a number of
saluer tous
accounts
les
on this
efforts
occasion.
déployés pour fournir
I
une
would like
assistance
to
technique,
commend all the efforts
établir
to
des outils
provide technical
d'investigation pour les
assistance,
crimes
offer
de torture et renforcer
investigation
les
tools
capacités,
for
préparer
crimes
des
of
outils pour la
torture,
mise en œuvre de
and
la
to prepare
Convention,
tools
échanger
for
aussi des points de
putting in
vue et
practice
des
the convention,
expériences
an
et
exchange of
organiser
points
des
of view and
réunions
experiences,
internationales et régionales
organization of
pour souligner l'importance
international and
d'adhérer
regional
et de
meetings
mettre
to
pleinement en œuvre
underscore
les
the
dispositions de
importance
la
to
Convention.
really put in
Dans
practice the
cette
dispositions of the
optique aussi, je
convention.
voudrais souligner que la
From that
ratification de la
perspective, I'd
Convention,
also
il
like to
demeure un
underscore that
acte
the ratification of the
orphelin s'il n'est pas
convention
accompagné d'une forte
mustn't
politique
be an orphan
de la
act.
part
It
des États
must be
parties.
accompanied by
Donc
a
voilà,
strong
au CTI, nous
policies from
aspirons à renforcer
the
les
involved
institutions, les
states.
politiques
So
et les
we'd like
pratiques
to
pour une
really
gouvernance
encourage
digne et fondée
organizations
sur des
and
règles de réduire et
institutions
prévenir les risques de torture et de
to
mauvais
act towards the
traitements.
reduction of all this.
Yeah, thank you, Ms. Barkan. You are highlighting the importance of dialogue and collaboration among states. So how do you see that, Ms. Pillay? How could CTI's modus operandi be useful in designing specific strategies leading to the universal ratification of the CD Convention?
Thank you, Madam Chair. I think Mrs. Bakan has touched upon many of the positive strategies of the CTI that has worked for the ratification of the UN Convention Against Torture. Specifically, CTI has found success through its formulation as an entity by states for states. This modality, this way of working has allowed for states to engage with one another on a peer-to-peer level and to discuss ratification strategies, challenges, and benefits openly in a way that they are sometimes unable to do with other types of actors. CTI has also, again, through the regional representatives of its core states, been able to build credibility through ensuring regional and contextualized approaches for states and not having a broad stroke approach. This allows us to really cater the activities and the support that is provided to states and can build appetite for ratification and improved implementation. Specific provision of support and guidance, including through the various steps of ratification, is also found to be helpful for states. Sometimes that's one of the reasons that states may be willing to ratify, but the intricacies of the process, including through the Office of Legal Affairs in New York, can sometimes delay this process or hold states back in practice. We've also found that oftentimes states don't not necessarily want to hold back from joining a convention or treaty, but there are competing priorities or the impression that a state has already addressed this in national legislation, or it's simply not seen as a pressing issue for a country at that moment in time. CTI has found that tying the convention to ongoing state priorities or other conventions that a state is a party to can open doors for engagements and conversations on ratification and implementation. And oftentimes it is the case that when it comes to conventions like the Convention Against Torture or Enforced Disappearances, that there are already pre-existing obligations that a state is a party to, whether internationally, regionally, or nationally. We've also found great value in concentrating and building on partnerships. CTI has built close partnerships with national, regional, and international bodies, both governmentally and non-governmentally. And this acknowledges that ratification is not an activity for a single institution, but one that is shared across the board and requires the buy-in of various actors. And lastly, I think one thing we found really works is amplifying the value of the ratification process in and of itself. Oftentimes, we see ratification as a box-ticking exercise, but in the process of countries ratifying, they undergo consultations, they undergo with non-governmental organizations, through their ministries, with citizens, and this creates momentum and can affect change. So I think there's a great deal of utility in placing value on the ratification process in and of itself.
Thank you so much. I also would like to ask you the question on both of you the question of giving us recommendations. I have just heard we have only 30 minutes left for the whole panel. You have already given some recommendations, so could you be very concrete, giving 1 to 2 recommendations for today's audience? And share those with us. So first to you, Ms. Palai, on the basis of your experience with CTI, could you share 1 or 2 recommendations with us?
Thank you, Madam Chair. I'll try to be very brief. A couple of concrete recommendations I would have is to continue to foster platforms and forums for experience sharing among stakes and stakeholders on ratification challenges and benefits. To develop and disseminate clearly the benefits that ratification and becoming a party to the convention will bring to states and to stakeholders. Also to have one-on-one engagements with states to understand challenges and hesitancies that may be holding states back, and to really communicate and disseminate the modalities of support that are already available for states through the UN, but also through various actors globally. And I would also encourage continuing to build strong partnerships with key actors such as civil society.
Thank you so much, and thank you for being so short. Ms. Bakan, which recommendations would you like to share with us?
Okay, thank you. Less than a minute. Just seulement quelques points. Donc, directement, quelques propositions de recommandation.
Okay, let me make some recommendation proposals. Reconciliation with the past and political opening are basic for any involvement in that direction. especially against forced disappearances, opening the gates to civil society as a crucial partner in the process of consolidation of the state of law. That we need a well-balanced and long-term funding, accessing the reinforcement of civil society, the role played by victims, integrate transitional justice in the multilateral and bilateral frameworks to encourage the integration of transitional justice in the framework of national policies, to abandon all reservations susceptible to compromise the goal of this, and the preservation of memory, and the main and the secondary sources of international law, the need to improve international systems for the protection of victims of forced disappearances, and another fundamental principle is the solidarity between states, the involvement of states that are members of the initiative through a bilateral and multilateral direct diplomacy, and each action should be accompanied by a well-coordinated and sustainable support through legal counsel and technical counsel. That's the summary, Madam the President.
Thank you very much. And I'm very sorry that I had to rush you through the last question. And I really would like to thank you for your participation and to share with us the best practices in the framework of the ratification of the Convention Against Torture, which I'm sure will be very useful for the universal ratification of the CED Convention. So thank you so much for being here with us. And we will now transition to the third and last panel of this session. Thank you. So the objective of this panel is to draw lessons from strategies focused on achieving the ratification of another significant international treaty, the second optional protocol to the International Covenant on Civil and Political Rights, which aims at the abolition of the death penalty. And I would like to welcome here Mr. Konstantinos Evstathiou and Mr. Raphael Chenay Hazan.
Perfect.
Perfect. Thank you. So, Mr. Konstantinos Evstathiou, lawyer by profession, is Member of Parliament by the House of Representatives of Cyprus since 2016 and is a socialist. He has been member of the Cyprus delegation to the Parliamentary Assembly of the Council of Europe since he was elected in 2016. He is also rapporteur of the Parliamentary Assembly of the Council of Europe on the implementation of judgments of the European Court of Human Rights. Mr. Raphael Chenay Hazan is director of Together Against the Death Penalty, ECPM. He is a specialist in international advocacy and public policies on human rights, UN bodies, and issues relating to the death penalty around the world. He has previously worked for international solidarity organizations such as the Red Cross, Secours Catholique Caritas France, and the Ministry of Foreign Affairs in Africa, Chad, Niger, and Cameroon, and in Asia, Indonesia, Sri Lanka, and India. He develops an ongoing dialogue with the diplomacies of abolitionist and retentionist state, as well as parliamentarians from many countries around the world to advance abolitionist strategies. So, in this final panel, we have only 20 minutes left, so I have to ask you to be a little bit shorter than you have prepared. So maybe instead of 3 minutes, if you can reduce your presentations to 2 minutes. I will also ask you each then 3 questions, and I will start with you, Mr. Evstathiou. So what are the strategies and tools used by the Parliamentary Assembly of the Council of Europe in order to achieve the global goal towards the universal ratification of the International Covenant for the Protection of All Persons from Enforced Disappearances?
Thank you very much for invitation and the question. I think that the whole issue depends on the political will of each state, each country, not only in Europe, but all over the globe. If there is no political will, I'm not sure that if we can achieve our goal so as to have the ratification of this important convention or conventions of the similar task and orientation. So the first thing is to implement the desire of political willingness to proceed with the prohibition of the enforced disappearance. This is the first one. The second one is that in order to help states which are reluctant to ratify the convention, technical assistance or even financial assistance can be given to them in order to overcome technicalities and financial problems. Mainly due to the fact that criminal or other investigations must start and go on in order to have this phenomenon ceased. So these are the main issues. And of course, there is always an open invitation to all other regional institutions, the African or the American institution of the same task, for open dialogue and collaboration. I think these are the most significant steps which have to be taken for this option. Thank you.
Thank you so much. Mr. Shini Hassan, what are the strategies and tools used by the ECPM to achieve the global goal of the universal abolition of the death penalty?
Thank you, Mr. Chair. Merci. Je vais essayer d'être rapide.
I'm going to try to be very brief. In 1981, when France abolished the death penalty, it was the 37th state in the world to abolish the death penalty. And nowadays, in 2025, there are 121 countries that have abolished the death penalty, and there are 26 additional countries that have not abolished the death penalty in their law, but they have a moratorium. So we have a total turning around of the trend, and we are continuing. But this has not been done out of the blue. With regards to the death penalty, there are a number of points about which there are common points, and there are certain differences with forced disappearances. With regards to the death penalty, the main point is, and I agree with what has just been said, it is about political will. It is all based on political will, and therefore a sort of political partnership that has to be established with the states. And I believe that we have been successful. We, civil society, helped by others, to set up this partnership for the abolition of the death penalty. First of all, the point was to put the death penalty point in all of the agendas and all discussion tables everywhere. 10 or 15 years ago, the point about the death penalty was established. It was a priority everywhere. It was not about human rights. It was not part of the human rights. The point about the state sovereignty that applied justice as it wished, and they had different tools available. And everybody was happy. Well, no, we have tried to place the death penalty issue in a dialogue position everywhere. And for that, we have taken my organization, the ECPM, has founded the first World Congress about the death penalty, and we will organize the next World Congress Against Death Penalty in 2026, invited by the French government. I will leave you with the leaflets. I'm going to distribute them in case you're interested. It has been an extraordinarily useful tool. And during the first Congress, I believe that we should take it as an example, as a model. We have also created the first Congress again. In that first Congress against death penalty, the first decision was made, all civil society organizations to meet under a great coalition, because the Congresses are held every 2, 3, or 4 years, but we need a follow-up. We need to work together. We need to actually work together. Sometimes when you're in the country, it's very difficult to actually advocate on that. And we need our neighbors, we need our partners. And the International Coalition Against the Death Penalty, which was created in 2002, has been a very good follow-up tool long term. And I would even say that we have installed one of the first things we have actually done is a World Day Against Death Penalty, a World Congress, a World Coalition Against Death Penalty, a World Day against death penalty, and to give pretexts, to give reasons to all of the world's civil society. And the last thing, and this is what allows us to be here today, is to turn the abolition of the death penalty to work in international institutions, to turn it into a standard rule. And that's an approach, I would say, I mean, the death penalty was not considered as a right. No, it was in the field of each state's sovereignty. Well, we're placing it together with the issue about torture and all sorts of racial, social, and other discrimination. So we have come together with all of the international bodies, including the United Nations in New York, and also our friend at the CDHB and other regional bodies.
Thank you so much. And based on these experiences and also the importance of political will that you are both mentioning, Mr. Sheni, how would you articulate global and regional strategies to foster the ratification of international treaties in general?
D'abord, ce matin, dans la cérémonie d'ouverture,
this morning during the ceremony, the opening ceremony, there is something that really touched me. We will organize our 9th World Congress Against the Death Penalty. And oftentimes, in all of the congresses we have organized, there are some times of difficult interaction between the victims who say something and the representatives of the state that also say something else, and it is in their hands to ratify the abolition of death. And we have to make the victims' organizations work. I mean, they have great difficulties, they have great suffering, and at the same time, we need to work with the very same states in order to ratify the abolition of the death penalty. We have not had that problem in our congresses, and yet we have started with a second protocol with regards to this. And when we actually came to the ECPM, it was actually a protocol ratified by 30 countries. And it was almost a forgotten protocol. It was totally discarded. Very quickly, we need to make people understand why this protocol is useful and interesting. Why is it important to sign it and ratify it? So we need to mobilize people and we need to explain, we need to do some pedagogics. And it is important, I mean, to ratify this OP2, the second protocol, to securitize the abolition and to avoid any reintroduction of the death penalty. And we have used the example in the last few years. Countries like Turkey or the Philippines, under the previous government in the Philippines, they truly had the will to reintroduce the death penalty. And they have been the fact that they have ratified that protocol did not allow them to do so, which shows the useful of this protocol. And the Congo, the abolition and the ratification of the protocol goes hand in hand with the same thing. Zambia, which is the last state to have ratified the protocol on the 19th of December last, not even a month ago, was also the last country to having abolished the death penalty. Now we have to work in a rationale, in a logic of going one thing with the other, and one should precede the other. There are countries that first went through the ratification of this protocol to then abolish in their parliament the death penalty, because that had already been done in the international at the international level. I have other things to say, but I'll say
Thank
them
you so
later.
much. And yeah, so Monsieur Cheny Hassan spoke about a sort of a relaunch of the second optional protocol and making its ratification a worldwide campaign, actually. And turning to you, Mr. Estavetiu, which strategies and tools mobilized by the Parliamentary Assembly of the Council of Europe is in order to achieve the prohibition of torture as well as the universal abolition of the death penalty, are useful strategies and tools that you think would be important to use for the ratification of the CED Convention?
First of all, we have to make a difference in the Convention, the European Convention on Human Rights. While the torture is absolute forbidden, the death penalty is not so clear forbidden in Article 2 of the Convention. Of course, the European Court of Human Rights jurisprudence make it clear that in a democratic society, state cannot kill in the name of law. So this is is the outcome of the jurisprudence of the abolition of death penalty. But to be honest, the voices for the introduction of death penalty are multiplied. I remember during my youth, the first attempt in the House of Commons of having back the death penalty, it was a proposition, scored just more than 30 parliamentary votes. Every time the issue is coming back, the votes are more and more. So I think, and this is the perception of the society. Unfortunately, when there is a tremendous crime, the first reaction of the ordinary people is to have the death penalty, and some political power, political personalities take advantage of these attitudes. And I think that the first problem we have to face is to implement the notion of proportionality, and the notion, and not to accept or to give the rise to this kind of narrative, which is totally unacceptable in a democratic society. This is the first one, the first thing. The second one is that torturing a person is like treating him or her as being a thing. And this is totally strange and unacceptable in a human being society. So there is no justification of a torture or the inhuman treatment to be allowed in our societies. And the question, of course, stays as it is, because it is easier for a non-democratic and ruthless regime, instead of killing, executing their citizens, either to disappear them, make them disappear, or to get them in prison in a rather unacceptable and non-proportionate reason. And this is the main issues we have to face. We have to be adamant against the neutralization of the citizenship of every single country. I repeat, you have already mentioned some countries. they try to have the death penalty back. But the main problem is not to allow to have legislation in such a manner that it ruins and distracts the meaning and the existence of human beings. Thank you.
Thank you so much for these insights. And although I promised at the beginning of this session not to rush to the last panel, I'm really sorry that I have to. And I will ask both of you to share some recommendations towards the universal ratifications of the CED Convention. And starting with you, can you share some recommendations based on your experience, and to keep them really short and concrete, please?
I mean, the convention against the forced disappearance. Yeah. Okay. I mean, we have already mentioned the intuition of helping the countries to go on with this ratification, but to be honest, I have to return to my first point. If there is no political will, no matter the technicalities or the intuitions or the motivation given to a regime, you can't force them to obey these basic and elementary issues of the mankind. The only thing we can do is, and I will repeat a proposition of the Armenian representative today, of creating a register of missing persons, and to have every year or two a conference, a global conference of what did the states at stake do in order to overcome or to minimize this terrible situation, terrible picture we have for them. So that will be something which can help them to choose between being on the side of on the wrong or the perfect side of history. This is the only thing we can do. We cannot bomb them. We cannot invade them. We cannot cut money because after all, the people are going to pay for that. So I think that besides this financial or technical assistance, this registrar and this accountability every year or two can help on that for that direction. Thank you.
Alors oui, évidemment que je le redis, c'est une
Well, I'm going to repeat it. It's all about political will, but we can actually. I have not lost hope. We do have the power. Me too. I organize the World Congress Against the Death Penalty. And I find that this first appointment should be an appointment in order to do this monitoring, this follow-up and monitoring. We need to monitor this. And we should be based on a logic of dialoguing. And civil society should be key. And we should work as a coalition. It must be a coalition that can actually work collectively. And I see Anina Boyash. We work hand in hand in order to bring forth the most difficult subjects, and it is by working with national institutions and human rights associations on this topic so that it is a discussion topic in each one of the states. I wouldn't go as far as saying that the issue about transparency is crucial, and we can work on transparency and monitoring. The documentation has been mentioned. No matter how difficult the topics, we need to work both on the documentation about the background and the form. We need to bring forth tools that are legible for the different interlocutors, whether diplomacy or the public opinion. And finally, to end, I also believe there is a lot of intersectionality with many different topics, with death penalty and torture. I believe that we need to also play with these intersectionalities. And to end, let me share with you an anecdote. I saw my friend Dimas, the director, president of the NGO Contrast, which was born in the 80s, on the kidnappings that come from both from the militias and the government in Swaziland, and I had the privilege of meeting in 2003 the founder of Contrast a few weeks before he was murdered by the government. So alert, we need to be alert. There is danger, and the defenders of human rights about these issues can also be endangered, and they must be aware. And the diplomatics too, and other initiatives we have undertaken about the death penalty, I believe, are very interesting. To create a group of friends, friends of the convention. It's a group of diplomatic friends, diplomacy friends that help us to bring forth this topic universally and to come to the World Congress Against the Death Penalty, please.
Thank you so much to the last panelist as well. I'm looking at the organizers of the Congress. How many minutes do we have for questions of the audience? Please, you have the floor.
Thank you, señoras y señores. Es un honor concluir to conclude this panel on the Convention for the Protection of Everyone Against Enforced Disappearances. Throughout the exchanges, we have had the opportunity to explore varied strategies that have enlightened us on the way to go. It's essential to acknowledge the crucial role from victims and organizations such as the ICAED, the International Coalition Against Enforced Disappearances, a promotion which for the ratification of the convention. Their testimony and engagement are powerful drivers towards these activities of the public that remind us that every figure hides a human history of suffering and hope. We have identified several huge challenges to overcome in order to increase the amount of ratifications. Among us, we have underscored the need for increased sensitivity and mobilize actors in civil society, which is of paramount importance. The feeling, as have been said in other conventions, such as the Convention Against Tortures, the Facultative Protocol, the International Pact concerning political and civil rights, shows that strategic approaches such as lobbying, documentation, utilization of the media are of paramount importance to surmount the obstacles so that the convention can be put in practice. The Bangladeshi experience presented by Mr. ASHRAFUZZAMAN shows that important elements can catalyze the international ratification of the convention, and therefore it is imperative to learn that lesson and to adapt the strategies in their respective countries according to the international context. In Africa, the work presented by Mr. Idrissa highlights the importance of work to protect against enforced disappearances, and these tools can also be used as the basis to encourage other African countries to ratify the convention. Morocco, as a core member of the CTI, has shown their historical support of the convention, which has had a positive effect on all the region. The actions in Morocco underscore the importance for strong political actors. The experiences shared by the CTI, the past CPM, remind us that there are well-defined strategies and tools that are adopted are essential to achieve our goals. The collaboration among states, NGOs, and international institutions is also crucial to create an environment that fosters ratification. In light of this discussion, it is essential to act. And our panelists have highlighted some of the significant actions, and I have synthesized them into keywords as a concerted effort to put them into action on a national level that is pragmatic and realistic and takes into account local realities, as well as the cooperation between states and civil society organizations. As the first key point, the strengthening of the role of victims. We need to encourage victims to keep documenting the cases of enforced disappearances and share their testimonies to the general public. The second key point is the creation of strategies for civil reporting based on a very specific cartography to the strengths and the weaknesses and the opportunities for each of the focus countries. And the third point is the mobilization of allies close to the government. We need to identify and form what we call champions in the governmental agency to sustain the ratification of the convention. Countries such as Canada, former Prime Minister Justin Trudeau was known as a strong champion of the human rights. The fourth point is the strengthening of regional and international cooperation. We need to strengthen partnerships between civil society and international institutions to foster better practices and resources. The fifth point as it is for reporting, we need to explore in the red lines in the reporting of forced disappearances to encourage states to ratify the convention. For technical assistance to countries to help them elaborate and put into practice whatever needs to be done to ratify and apply the convention. The seventh point is to sensitize general public and the media. We need to launch sensitivity campaigns to enlighten the public on the Convention of Human Rights using traditional media as well as social media. The eighth point, we need to foster zero impunity policy. We need to insist on the need for justice for victims of enforced disappearances and the fight to punish the authors of this crime. The last point, you said it yourself, we need an evaluation on progress. We need mechanisms of evaluation for the application of the convention, implying all parties at all levels. The universal ratification is an ambitious goal, but it is completely attainable. It just requires a collaboration between government, civil society, and victims. And we all need to work together to strengthen our commitment, to mobilize necessary resources, and enlighten the public. Therefore, we can wait a future where enforced disappearances are seen as a human rights violation and are combated with efficacy. Thank you.
Thank you so much for this very comprehensive summary of this afternoon's strategies and recommendations. That was very useful, and it rests me now to thank you, all the participants as well as the audience for coming to this panel and for your valuable insights and that you have shared with us today. Thank you so much for that.